about this next panel discussion. Nancy Poppe is an off-time participant, panelist, moderator. She's very unselfish, a giver of her time on behalf of EBA. And she's with Willards Towers Watson for 25 years experience as an insurance broker serving the needs of yachting customers. And it goes on. And I don't want to minimize her bio notes because they are in your program. So I will give a little one-liner from each, but in a matter of fact, look into the background experiences of some of your moderators and presenters, and I'll turn it over to you, Nancy, to talk to us about marine insurance challenges and solutions.
Thank you, Bob, and thank you everyone for coming today. And I also want to thank the IYBA folks that spend so much time putting this on, so much time and energy, and it makes it run so well. And also for all the panelists that are joining us today. It's a volunteer job. So thank you, everyone. And just so briefly, unfortunately, one of our panelists, Jonathan Chapman, is mid-flight, coming from a cold zone where his plane had to be de-iced. So I guess he's been a bit delayed. So I will play the role of Jonathan today, not nearly as well as he would. Sitting over there to my far left is Charlie Davant. And I'll just give you a brief synopsis. I know, as Bob said, it's in your program, but I'm going to add my own flavor here. So Charlie is an attorney at Davant Law, PA, and Charlie brings his extensive experience and passion for maritime law to the forefront with his practice dedicated to maritime product liability and insurance. Charlie has established himself as a trusted advocate for his clients. So it's unusual for us to have an attorney such as Charlie here because he doesn't represent vessel owners. He's an insurance defense attorney. And when we talk about, I feel actually very privileged that Charlie's joining us today. And when we talk about insurance, which is our topic, and how not to put yourself in the crosshairs of your insurer, who better than Charlie to give us some insight into the people sitting on the other side of the table, so to speak. And then Juan Carlos Merle in the middle is Vice President of Global Insurance Group. Juan Carlos has a master's degree in risk management insurance, so he's the one, from St. John's University. And St. John's is one of the premier risk management schools in the whole country. So very credentialed person sitting here with us. And so Global Insurance Agency, GIA, GIA, I think he calls it both, is a tech-forward, comprehensive managing general agency providing cutting-edge solutions. So Juan Carlos has been working for years to bring a new private and pleasure marine insurance program to the marketplace. And I asked him how long it's been since someone brought a new product into this marketplace. And I think we said 10 years or thereabouts, a new, meaning new security, or new program, not new security. So as an insurance broker, essentially, who brought together 3 insurance companies to back his program, he knows all about the ins and outs, the whys, and the minds of underwriters when deciding why not to be in this business. So with that, this photo is courtesy of Charlie, and this is the old Lloyd's marketplace, so to speak, where insurance, or modern insurance, was born. I'm sure I can do this. This is the new Lloyd's, where insurance is still done in a very personal way. You can see around the edges are what they call the boxes. I love this history. It's so cool to me as an insurance nerd. In the middle there is the clock tower, and underneath is something else. But there was supposed to be a photo of a bell there. And it's the Lutein bell where they ring for significant events, and it's been there for many, many years. There's my Lutein bell. Okay, so I'm going to quickly start with Insurance 101. It's pooling of risk. It's spreading of risk, which is an important element. It means spread around different types of exposure, so you're not always the one paying the claims. It's the law of large numbers. What's crushing to one can be made bearable by all. So we're all familiar with this concept when we insure our cars and our homes. It also adds to social responsibility. I mean, as a policyholder, I'm responsible not just for my own stuff, but making sure that I'm not doing things that cause other people's rates to rise, because this is a pooling of risk and a sharing of risk and costs. It's a transfer of your risk to an insurance company to reduce your financial uncertainty and make your finances more manageable. And in transferring your risk, you pay premium. And the other Insurance 101 is insurance companies are mainly for-profit organizations. There are some mutual associations, but they're few and far between. So insurance companies need to make money, and we all hate to hear that, but that's what they're there for.
So do casinos.
Thank you. And then anyone who knows me knows my favorite line is underwriters are people too. It's easy for us to sit here as I'm a broker, and talk about, well, why can't they do this, or why don't they do this? They're people too, with jobs that have to, protect their job and protect their company. And so getting to know them and building a relationship, and we're going to talk about this later, is part of how you get business done. Oh, sorry, that is my favorite slide of the whole thing. Does anybody know what that is? Any guesses, even from the panelists? Nobody? Well, that drop represents marine insurance premium to the overall premium in the world for insurance. So globally, now property and casualty is a segment of its own. There's life insurance, there's financial products, so none of that concerns us. We sit in the property casualty market. Marine does, as do homes, cars, art, businesses. So there's $3.6 trillion in premium around globally in the property casualty market. As a subset, all marine is about $40 billion. So that's 1.1%. And that subset of all marine includes cargo, which is an enormous component of marine insurance globally. Ships, cargo ships, some recreational, which is the third subset of about 1.8 billion. So we are 0.05% of the global insurance property casualty marketplace. So when you wonder why underwriters, insurance companies don't want to insure vessels, it's because their 0.05% can probably make more somewhere else. And we did kind of talk, do we know how much the true yacht market is of that? And I don't, but it's even smaller. So we're going to just quickly, I'm now Jonathan. Jonathan, as a yacht broker, has lots of clients, wants to sell boats. People want to buy boats, and insurance is always an issue and oftentimes a thorn. So why is it so hard to get? Why is it so darn expensive? And why isn't there more of it available? So Jonathan had some specific scenarios we thought we would touch on and talking with Juan Carlos about. So Jonathan had a 55-foot center console with quite, 5 engines, quite sporty. The buyer had a sketchy motor vehicle record, but he already signed acceptance. And the buyer could not get insurance. So I wonder if you have any comments on that.
Yeah, it seems like a sketchy boat. I wouldn't insure it just with that, without more information.
So I think the issue that started this was the buyer already signed the acceptance, and the only way he could back out is by losing his deposit. So they were looking for insurance as a solution to protect his deposit, and perhaps should have looked first for that before he signed the acceptance. The next one is a pristine 1980 boat of a brand of build that we all would know. Everything was, perfect in the survey. Everything had been replaced except the hull. So basically just the shell of the vessel was 1980. Everything else had been renewed. And yet when the buyer wanted to get insurance, it was seen as an old boat.
See, this one and the next one, for example, if it's hard enough, and I'm sure we'll get into that in a minute, of getting bread and butter boats into a program, when you start doing kind of extremes, 1980, 1950s, older boats, you just start adding more limiting factors. Let's just forget everything else it says there and just focus on the year. Most yacht insurance programs have treaties with their reinsurance and their capacity providers that have outlines of what they can and cannot take on their program. So if there are limiting factors, a 30-year-old boat, right? They can't insure anything more than 15, 20, 30 years. And you had a 1980 boat and the broker's yelling at you, hey, this is the best boat I've ever seen. I guarantee you there's not a claim. The process of just getting that approved through the reinsurers and bothering them with this one-off request every single time you have to do it, and I'm just speaking for my program specifically, it just doesn't make sense. So, if there was a program dedicated to pristine old boats that made money, there would probably be a program for that already. And that's where I would place that boat.
So you're saying that just the age alone could throw something out, regardless of the quality, the survey, the ownership track record?
Yes, it could.
That's an interesting point to take away. That tells me that no matter how good of a story you've got, that you're going to already face an uphill battle and perhaps find someone that buyer already has a relationship with that might look upon it differently.
I think a lot of these MGAs, managing general agents, have the pen, as it's commonly referred to in the insurance industry. And that pen is only for certain parameters, certain size vessels, certain valued vessels, certain aged vessels. So they don't have any wiggle room, which comes up in some coverage cases that you have when they don't have a pen for a certain X sort of representation and nobody tells the insurer what's going on. They don't have the ability to write it, so it makes it a material fact that can void the policy if the truth isn't told.
Which we will definitely get into material fact in a minute. And another scenario that Jonathan had is the vessels. He said he's seeing an increase in vessels that are donated and then they're chartered or leased on a long-term basis. And he was asking, how can insurance protect the charterer's financial interest? Because the way it will work in the event of a loss or a claim is the proceeds from the insurance policy, which is the insurance policy taken out by the charterer, will go to the owner of the vessel, the charity. And I don't know, I'm not sure that that's an insurance problem.
Not necessarily. I mean, the insurance contract is going to pay whatever the contract says the insurance contract should pay. So if it's the insured, then the contract will pay the insured. I think you could maybe put them in as a loss payee, like a bank is always listed as a loss payee. That's perhaps one way to solve that problem, or have some kind of deal between the owner and the charterer in advance and in anticipation of a loss, that insurance proceeds will benefit the charterer.
So perhaps having it in the lease or charter contract saying, charterer, your interest is X, and owner, your interest is Y, and this is how we agree to split the proceeds of a claim.
Right.
So that's more of a legal matter than an insurance. I mean, the insurance will follow, perhaps.
Right. I mean, the insurance policy will pay whoever the owner is, or the insured is, but if the insurance company is told the situation in advance and you anticipate this problem, you can perhaps work that out with the insurance company before the loss happens, which I think is a critical thing to think about when you're writing insurance. You've got to be forthright and honest with your insurers as to what you're representing your vessel to be. And as long as you tell the truth, you're generally going to be okay.
More to come on that. And then Jonathan brought up survey recommendations, and I told him this was my one of my hot spots too. Insurance companies want the owner buyer to sign a letter that says all recommendations from the survey were done. Well, all means every one of those recommendations, not the ones that somebody felt were important to do and the rest can be done later. It means all. And I don't think anyone should be signing a letter that says all recommendations were done unless they were all done. I would love to see surveys written in such a way that they identify not just asterisk items, but that they identify, do these within 2 months or a month, whatever the time frame, do these within 6 months, and then these are optional. Because you can get an insurance underwriter to buy into that process and timeline versus here's a list of everything the surveyor came up with. Some of them have stars for safety, and the insurance underwriter doesn't want to get into the nitty-gritty of the survey. That's the surveyor's job. So unless the surveyor says that something's not important to do, the insurance underwriter certainly isn't going to say something's not important to do. So I think more time should be spent on discussing surveys and their solving the recommendations before anything's signed. I don't know, do you see that in some litigation too?
We do, and I'm mindful that some of the people in this room I have coverage cases against, so I'm going to try to be careful with what I say. But I think, again, it's all about telling the truth. So oftentimes, I'm a boat owner myself. You're excited to buy the boat. You've got the financing. You finally found the right boat. You've got the contract, and the insurance is considered maybe the last piece of the puzzle. And you are getting a bunch of information from your insurance agent, and the owner is in a rush to sign documents, whatever you need, signing applications, also something that you need to be careful with, but also signing off on survey recommendations. So if you have cosmetic, the TV doesn't work, or something that doesn't affect the seaworthiness of the boat or something like that, and you don't want to do it, but you sign a document that says you have, the insurance company is going to have a problem with that later on because you didn't tell the truth. But if you go back through your insurance agent to the underwriter and say, hey, I'm going to do items 1 through 10, and items 11 through 20 that don't have anything to do with the seaworthiness of the boat. It's a TV, it's a radio, not a VHF radio, the Bluetooth music that you want to play at the sandbar. Tell them that you're not going to do it. And don't sign a survey recommendation that says that you complied with everything, because the insurance company is allowed and will believe what you tell them. And if that's a lie and there's a loss, that can cause a coverage problem for you down the road. And, as a yacht broker, you're one of the first people they might call when they're upset because their asset that they've invested in doesn't have any insurance coverage.
That's a big one, I think. Do you have anything, Juan Carlos, on that?
No, I mean, just looking at all the scenarios, apart from what I said, I think it's important to know that everything is insurable. Everything's got a price. That is the mentality. At the end of the day, it's a for-profit entity. So just pick and choose whichever one of those. A 55 center console with a DUI owner, say, well, how are you going to underwrite this? Give me who's going to be the captain? It's going to be owner-operated. Well, that just seems like, just given that piece of information, it seems like he's going to drive the boat drunk, right? That's just preemptively what you're thinking. And it's might be a cigarette boat, might be going, super fast, ripping down the waterways. You're thinking, well, that boat might worth $1 million, and, you might have to put, a $100,000, $200,000 deductible. And, shoot, if you're willing to pay $80,000 to insure that, you're going to lay it up during hurricane season, and I'm going to exclude a windstorm. Let's take a crack at it. I'm in the risk-taking business, The problem is when you underwrite it that way, the first response you get is a gut kick, like, you're insane. I'm not going to pay $80,000 for, blah, 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 blah. And as an underwriter, you're thinking, well, shoot, I didn't want to underwrite it either. You came to me, trying to convince me to write this, unseaworthy, for lack of a better word, boat. But, if you're forcing me to tell you what I'll do, here's what I'll do. So that's kind of my stance on it. I try to be as transparent with the people that I work with.
I would just add on the surveys, that the product that you're selling, because I think it's critical. I mean, as a yacht broker, the boats that you're selling. And if you're recommending an insurance agent, you should know that that insurance agent also knows the product that he or she is selling. And the reason I say that is because insurance policies vary widely. Some companies, they don't care as much about survey recommendations as other companies. Some policies have a warranty written into the policy that says that if you don't comply with the survey recommendation, the policy is void from inception. And if, depending upon what law applies to that policy, whether it's Florida law, New York law, Texas, California law, how that warranty is interpreted can also vary. So, have a conversation between yacht brokers and insurance brokers, lawyers, your clients, and make sure everybody goes into the transaction with eyes wide open. as to what's going to be covered and what's not going to be covered, and know your policy and know the product that you're pitching. You're getting, as an insurance agent, 10, 20, 15% of that premium, and that's worth something. So you need to know what you're selling, and because I can tell you from experience that when you tell someone that their $5 million asset is not covered, you can imagine the reaction that they're going to have. They take it out on me as the lawyer representing the insurance company, but they also take it out on their broker, both their insurance broker and their yacht broker.
Yeah, we all have a stake in it. We all want happy owners, ultimately happy and well insured.
Check out. Yeah. So Nancy just asked me to. This is a silly slide that I have. This is just my viewpoint of the insurance placement, and it's, I'm a very graphic crayon kind of a person, but I think ultimately it's about the meeting of the minds, which is that image in the top right corner. Right, you have the yacht broker, or the yacht owner on the left. You have the insurance agent in the middle, and on the bottom you have the underwriter. And everybody in that column, if you will, has to be on the same page, which is what I'm talking about. Everybody has to understand what the risk is, and understand what the policy says, and understand what's covered and not covered. And if any part of that transaction and that communication fails, you end up having a problem. And I think, for the insurance agents in the room and the lawyers, you probably have lots of stories about what that looks like. But I think that if the more communication that you can have between and Nancy does a great job of this, between the customer, the owner, or the owner's representative, and the underwriter, the better off you're going to be. And I'm saying communication. This doesn't mean WhatsApp, text messages, and phone calls. I'm talking about emails, things in writing. There's a saying in law that if it's not in writing, it didn't happen. And I can tell you when these losses occur and everybody gets their files, because remember, as a yacht broker and insurance broker, your files are going to be subpoenaed, and you're going to have to produce every document and every piece of paper that you have that relates to that placement. And so you, as an insurance broker, if there's some warranty in the policy that the customer needed to have known about, you want to have in your file an email that told the customer or the customer's representative about that warranty. And if you don't have that, it's going to create a problem for you down the road if there's no coverage. But in terms of the actual placement of insurance, this is just a diagram of how I think about the meeting of the minds.
And you just said something that made me think of some maybe advice for yacht brokers, particularly folks that have been doing this for a long time and very successfully selling boats. You might get used to the way insurance works because you have so much exposure to it, and then you come to think that things are the same as before. So you might find yourself saying, "Oh, well, I know how this company does this, or I know we can do that over here." But these times are a-changing, and so even us that do this every day, we can't rely on those types of historical actions to get us through. We have to check on everything these days. So more on the insurance placement, utmost good faith. I think this is for the underwriter and the attorney here to talk through and kind of, I think we just covered some of it.
Right. So ubere me fide is a word that nobody knows how to spell or pronounce. It's supposedly Latin for utmost good faith. And essentially what the cases say is that the owner of the vessel, the customer that's seeking insurance, has an obligation to place the underwriter in their shoes. And everything that customer knows or should know has to be made known to the underwriter, as long as it's a material fact. And if the underwriter is not made aware of a material fact, and I want to stress one thing, it's not just misrepresentations, which are a problem, where you perhaps misrepresent your purchase price of a vessel. Happens more often than you might think. Or you answer a question incorrectly on the application. It's also related to non-disclosures. So if there's something that the customer or owner knows that's material to the risk, they have to disclose that to the underwriter. And if they don't, and a court determines that it's material, then the policy will be void from inception, which means that all the premium gets refunded to the owner and there is no policy and the insurance company walks away, which again can be a really bad situation. It's a draconian relief is how courts describe it, and nobody likes it.
And as an underwriter who's on the other side of this, what are your views on that?
I mean, obviously, I got a insurer for a law. I mean, a lawyer for an insurance company next to me, so I like what he's saying. But I agree with it completely. If you just take away all the fluff and you focus on what you're doing, is you're paying someone a couple dollars, many dollars to insure something else, and they're just saying, look, for me to know that I'm going to insure it, give me these, documents. Sometimes it's a lot, sometimes it's not as much information, but if the limited information that you have on those documents is incorrect, then it's a twisted deal from the beginning. If we were doing a handshake deal and you were saying, hey Bob, come will you insure my boat against risks? But then you say, all right Bob, do you have any problems with it? No, it's brand new. But then it turns out there was a million things wrong with it. You could see how that in a saloon or a bar or something could turn into an issue when you start developing with people like Charlie here, and they'll take you to court and solve these things with a matter-of-fact point of view. Then it'll get resolved quite quickly that you weren't telling the truth, especially with all the information nowadays on the internet. If you're chartering your boat and you're not saying you're chartering your boat, or a lot of stuff, it's really easy for me to find that out. I mean, even someone like me could just log in, find something on the internet and say, look, this guy's lying all over the place. Same thing with like the surveys, right? If you're saying you finished all the surveys, but you didn't fix, 30 cosmetic things, but you said you did, when you told me you did, I painted a picture of you as an owner. I said, this guy takes care of all the cosmetic stuff, not only the security stuff. This is his prize, his pride and joy. He loves this boat, or she loves this boat. Well, it turns out, no, that they only did the bare minimum to get through the survey, for whatever reason. Doesn't mean it's good or bad. It's a different piece of information than what you signed and told me that you did.
That's an excellent point, and I think we don't talk about that enough in the industries as a whole. But as yacht brokers, you have, let's say you want to sell a yacht, you know the yacht, you learn the yacht, you present the yacht in such a way that it's a good story. You highlight the best features, you give it a personality. I mean, you that's your job, and that's how you sell it. Well, that's, as an underwriter, same thing. Owners, you develop a picture of the owner and based on certain things. And so an owner who's constantly feeding you information and wants your input and bringing you into their picture and their world, over time you build a relationship where you can start to trust. And when they want to do something a little left of center, you think, okay, I know them and how they operate. I can live with that. Whereas if you're misrepresenting that you did cosmetic things, that seems probably very simple on the surface, and it might have even been an omission of innocence. But to the person who doesn't know you sitting behind the desk, because underwriters are people too, it paints a picture. Wait a minute, they couldn't even tell me that. So thank you. And how much time do we have, Lee? 10. So do we want to talk some more? I think we covered material fact quite a bit, unless anybody wants to. I want to leave a little time for questions and for me to learn. Do you want to talk about any cases?
So I do, and I'll try to be careful about names, but this case is really old. So it's public record, so I'm not divulging anything that someone might be able to find out on an internet search. But there's a case called Brymere that was from, it's actually from 2009, because I just looked it up this morning, so it makes me feel old. But this is a case that I think is very interesting for us to all learn from. One of the things, I go over to London quite often and meet with underwriters and Lloyds, and I think that London does a really good job of talking about losses that occur so that they can learn from each other, and American insurance companies do a terrible job of that. Nobody to try to sweep it under the rug. I think we would be doing well as an industry to talk about bad things that happen, to learn a little bit more and to try to avoid those mistakes in the future. So I'll give you a bad thing that happened. The case of Brymere, a wealthy real estate investor in Pennsylvania gets interested and purchases a 66-foot sport fishing vessel from a yacht broker. And he's the second owner, which is an important fact. And he has a pre-purchase survey conducted by a surveyor that has all accreditations that you would ever think would be required. And that surveyor, for reasons unbeknownst to anyone in the case, created two surveys that were identical in all respects except for one. There was a $225,000 price difference in the valuation, one which matched the purchase price and one which didn't. The surveyor or the owner used the higher survey to obtain insurance and place the risk at about $1.5 million. And he uses the lower survey at 1.3 or so to obtain financing. And he also, the owner, buys the vessel in the name of an LLC as is mostly done, but he doesn't tell the insurance company that. He writes his application, signs it, and it's in his own personal name. So the and during the pre-purchase negotiations, there's obviously an inspection by the owner. There's an inspection of the surveyor, and the yacht checks out. It's a Donald Blount designed, beautiful Carolina sport fishing boat. And so the deal closes, and on the maiden voyage from South Florida up to Rhode Island, the mate heads down to get a sandwich, and he realizes that the chine is beveling in and out about 6 inches, and everybody starts to freak out, of course. And so they take the boat up to Hinckley in Portsmouth, and they realize that there's a couple of severe problems with the boat. One, the longitudinal stringers have been severely underbuilt. The plan, they were cut 10 feet short. All 4 of them were cut 10 feet short at 90-degree angles. And if you know anything about boats, I think everybody's nodding. You know, that's not good. In addition, this is a foam core construction boat. The plans called for 1.5 inches of foam core, and the boat actually only had 3/4 of an inch of foam core construction. So you can imagine a wealthy Pennsylvania business owner gets very upset, and he ends up filing a lawsuit in Fort Lauderdale, and he sues the surveyor, he sues the prior owner, and he sues the yacht broker. And just a word of caution, because I pulled up the order. One of the defenses that the yacht broker used was that this is an as-is contract. And this is from a district judge, that the invocation of caveat, so the yacht broker used as-is, caveat emptor as a defense. And you knew what you were buying. I don't have any responsibility. And the judge said, yes, you do. In an arm's length transaction, it's a powerful, but it's not an absolute in its reach. That the doctrine of caveat emptor will not shield fraud or deception. So they sued the yacht broker for fraud, and essentially arguing that how could you not have known about these defects in this boat? They were so patent, they were so obvious to anybody that had half a brain that you should have known, the surveyor should have known, and the seller should have known. And I will tell you, because I watched it happen, they went to trial and in front of a jury in Broward County, and they got a $2 million verdict against the yacht broker, and the seller and the surveyor were dismissed during the course of the trial. In addition to that part of the case, there was a second case. Mr. Yacht owner was insured, and of course the insurance company had something to say about this as well, because they didn't know the correct purchase price. So they had a problem with the fact that they weren't told the truth about the purchase price. They had a problem with the fact that they weren't told the truth about who the owner of the vessel is. And there's an exclusion for latent defects in the policy, which were defined as ones that could be discovered by known methods of testing or ordinary observation. And so the argument from the insurance company was, well, hold on, Mr. Yacht owner, you sued this yacht broker saying that these defects were patent and obvious. You know, that's not covered under our policy. how can you argue now that there are latent defects that are covered under the policy? So it's an important lesson. Ultimately, there was no insurance coverage, but the yacht owner was made whole through the fraud lawsuit. But I think it's a very important warning for yacht brokers and insurance agents in that case to be very careful with the information that you're receiving and what you're transmitting to the underwriters, that it's as truthful and accurate as you know, and that you can, be transparent in what you're doing, and make sure that all the information you're getting from the yacht owner is being delivered timely, without any reservation to the underwriter. We had another case called Sunset Water Sports, tragic double death parasailing case in Key West, and unfortunately, the insurance agent in that case told me in a deposition that he decided based on severity when to report losses to the insurance company. Right, I see a couple heads just go down. And they had 20 unreported losses. So the agent was acting as a filter, right? Instead of just a transparent, fluid information. And so the policy was voided from inception in that case. So you can really get yourself in trouble. I'm sorry to drone on and be the bearer of bad news, but that's the cases that I've seen that I think are very good words of warning.
Well, thank you. And that's, hearing those types of terrible, tragic stories is really where the rubber hits the road. So we all do what we do to avoid those things, and then to learn from other people's mistakes is really powerful. So thank you. And I don't know if you have anything to add before we throw it out to questions.
No, this is your chance to ask the dirty questions. Go ahead.
I reserve the right to take the fifth.
What?
Joe's back there.
Thank you. Scalise's always got something to say. There seems to have been a rash of large yacht fires in boatyards in Fort Lauderdale. Can you speak to any of those possible reasons why, or things that we might be able to learn and pass along and be more cautious of?
Lithium-ion batteries. That's the main killer. There's a lot of different reasons for it, but those toys, hydrosails and all those stuff that they put on there, those lithium-ion batteries overcharge, overheat, catch fire, fiberglass. It catches on quickly. It is not just in Fort Lauderdale; it's around the world. Great point, though. That's something that we've been dealing with on the underwriting side to minimize as much as possible. At the end of the day, a fire loss is a fire loss, so maybe a fire deductible. Just requesting applications to note more care of what lithium-ion battery powered toys and stuff you'll have on your boat. I think underwriters will always appreciate that preemptively and help you avoid some type of exclusion towards that.
Yeah, I think from an insurance perspective, this is a good example of why you want to make sure that the truth is being told on your applications, right? Because you don't want some technicality to ruin your client's possibility of getting repaid for that fire loss.
I think the polar bear case is the one that sticks out in my mind, where the boat pulled into a marina or a shipyard on the West Coast, and under quick sign this, and the captain signed a waiver of subrogation against the yard. The boat, from memory, the boat next door was having welding and caught fire and caused the polar bear to burn completely. So the insurers for the polar bear, well, I'm sorry, you signed a waiver, and our policy says that you cannot sign a waiver without our approval, and they had not given approval, so they had grounds to deny the owner's claim. And that wasn't even hot work on the boat that burned. It was the boat next door. Sorry, Paul.
Quite all right. Yep.
Hi. Yeah, my question was, I think we sort of missed the slide on material defect. How often are we seeing where the misrepresentation or the failure to disclose is, not related to the peril or the cause of the loss, but is used for denial of coverage?
I mean, if it's a warranty, I think there's great court cases recently resolved. The Great Lakes or Charter Lakes case. a lot of programs, and my counsel told me not to name names here in a room full of other lawyers, so I won't name names, but certain other programs have been very, very, very successful at specifically what you just mentioned. You breach a warranty or a material piece of disinformation unrelated to the loss, you breached it, policy's over, bang, bang. Unfortunately, that's the way the U.S. manages these type of things, as far as I'm concerned.
Yeah, so I think it's important to distinguish between warranties and uberame fide. So warranties are written into insurance policies. They require you to do X, Y, and Z. Under New York law, if you violate a warranty, it doesn't matter whether that violation is causally related to the loss. The policy can be voided from inception if the policy language says it is. End of story, full stop. That's it. There is no discussion about whether or not it was material. Uberame fide is a different doctrine, well-entrenched federal maritime precedent that says that if you don't give me all the material facts that I needed to assess whether or not to accept your risk, then I get to void the policy ab initio from inception. Now, whether or not something is material or not depends upon what circuit you're in. In the Third Circuit, purchase price is material as a matter of law. Same somewhat in the Ninth Circuit and in the Second Circuit. In the 11th Circuit, which is Florida, Alabama, and Georgia, it's always going to be usually a fact question unless reasonable minds could not differ, essentially a judgment notwithstanding the verdict kind of a standard. But oftentimes when you get into these cases, you have an underwriter that's testifying as an expert, and there might not be a factual dispute that has to be determined by a judge or a jury.
My question for Charlie was actually on the same subject, which is breach of warranty. You talked earlier about the importance of governing law in breach of warranty issues. Could you talk a little bit about the fallout from the Great Lakes v. Raiders Retreat case?
Yeah, that's a good question. Thanks. So Great Lakes versus Raiders Retreat went up to the Supreme Court of the United States. And essentially, to try and give a quick summary of it, it was about whether or not an insurance contract could select the law that applied to that contract. And the Supreme Court, in a 9-0 decision, how often do you hear of a 9-0 decision in this political climate of the Supreme Court? But in a 9-0 decision, the Supreme Court said, yes, you can. And you don't have to have an office or a reasonable basis to choose that choice of law. And I think it's important to consider, in not just insurance contracts, and this is specifically to marine insurance contracts, but the Supreme Court said that any marine contract can select a choice of law and it will be presumptively valid unless there's some sort of fraud or overreaching kind of a situation that would exist. But I don't think that any of those are ever going to happen in the transactions that we're talking about. So Raiders Retreat said New York law is fine, or any state law that you want to pick. But insurers are always going to pick New York law because there are no recovery of attorney's fees in insurance contract disputes. Warranties are strictly construed, and there's no bad faith actions. So those are 3 really good reasons, if you're an insurance company, to select New York law. And I think there are others in other non-marine insurance contracts.
Or you can choose to settle the dispute under the auspices of the International Yacht Arbitration Council and choose your venue.
Arbitration is strictly enforced.
There you go. Any other questions from the audience? There you go.
I'm a yacht broker, and I have a question about the disclaimer. So when I go to list a vessel, there's that disclaimer at the bottom. Doesn't that address the condition of the vessel? I also require my listings to sign a material damage disclosure. So it's incumbent on the seller to disclose. Are those 2 valid?
Not in the case that I was talking about. Okay. That's what they tried to rely upon as contractual language in the contract. But when you're talking about fraud, it's the F word in law. And, it's the other F word, right? And it's a huge problem. And so it's essentially as if that contract never existed because you were duped into entering into it because you didn't tell the truth that you should have known about what the condition of the vessel was. But these conditions, it's not just, these were serious problems. There were core samples. I didn't give you the whole story. There were core samples that were given to the owner of this boat, and represented to be that of the boat, and they weren't. Right. So there were like lots of facts in the case that happy to talk to you about that sort of everybody kind of cringes when they hear. And if you're cringing about a fact like that, I think you have a problem. And you need to, think about what you're doing and make sure that you're disclosing all of that to the buyer of the boat.
The case that you're referencing was the impetus for IYBA to create the listing agreement and the purchase and sale agreements that you have available to you to use as the foundational elements in your transactions, because of the faults that were found in all of these varied agreements that basically stemmed from the back of a napkin at Chuck's Steakhouse on 17th Street, which is what we use to structure our deals. A handshake and a correct spelling of your name is what we used to use. And now, due to that case, the IYBA, which at that time was the FYBA, chose to step up and engage Robert Allen Law and some other great minds in the industry to bring forward documents that can be the foundational elements for your transactions and offer you at least some of, if not all of, the protections that you need. These documents are not all-encompassing. Addendums and amendments are recommended. Call Todd Lochner. Call Moore and Company. Call Alley Moss Rogers Lindsay. Call your attorney and ask to make sure that the deals that you're doing are specifically addressed under your documents to make sure you're covered from A to Z and keep the insurance guys off of your back. Ladies and gentlemen, thank you so much. Bob?
Thank you.